and thank you very much, everybody, for joining this AFME All Members call today. The topic is the new UK regulatory framework, planning for change in 2023. Thank you again for joining us. I think we will kick off in earnest now, given that we have well over 100 participants on the call. Thank you very much to members for your time today. My name is Julian Allen Ellis. I'm Director of UK Advocacy and Capital Markets here at AFME, and I'll be your host and moderator on behalf of AFME. I'd also like to extend an especially warm welcome to my colleagues from Clifford Chance, Caroline Dawson and Chris Bates. Caroline and Chris will need no introduction to those members who are active in AFME's financial regulation and global financial markets workstream. They're invaluable and expert partners, and I'd like to thank them very much indeed for making their time today to give this presentation. And before I turn over the floor to them, I'll make some very brief housekeeping and introductory remarks. We'll operate under the Chatham House rule to encourage an open and unfettered discussion. As this is an all members call, there should in fact be no members of the press present. However, we will retain the operating under the Chatham House rule. We have an hour, just one, set aside for this session. Chris and Caroline will run through a presentation, and we'll save some time for Q&As afterwards. Please do feel free to submit questions in written form through the Zoom app. There's a Q&A pop-up you can use at the bottom of your screen. Apologies in advance if we don't get to everybody in the limited time available. Without further ado, we'll hand over to Caroline to talk us through the not insignificant amount of change in the UK regulatory pipeline at the moment, and look forward to hearing your questions and comments at the end. Over to you, Caroline. And I think we've had a very inopportune moment for Caroline to freeze, but she appears to be back with us now. Let's see if we can hear her as well as see her.
Brilliant. Hopefully you can hear me now. Yeah, perfect. Sorry about that. Yeah, I'm down in Cornwall, and obviously the hamster powered internet doesn't seem to be holding up at the moment. So yeah, that was perfect timing. So yes, thank you so much, Julian, for that introduction, and thank you very much to AFME for inviting us to come in and present on this. So just very quickly before I move on to the actual meat of the presentation. So the idea today was really just to give a bit of an overview of the future UK regulatory framework, and then talk through what we're expecting to see in the course of 2023. So basically the key building blocks of the 2023 reform programme, and then just pick out some of the selected topics that we think are most likely to be of interest to AFME members, so focusing on wholesale markets, sustainable finance, capital markets, and then the slightly mysteriously titled other. So just moving on to, I suppose, just by way of a bit of background, where we are at the moment and why there's any kind of a need for reform of UK financial services regulation. And I mean, I think this slide probably illustrates quite nicely where we've ended up. So obviously at the end of the Brexit transition period, we had this process of onshoring all of the retained EU legislation. And the idea really of the onshoring process was to make targeted amendments purely aimed at making the onshore legislation function as part of the UK rulebook. And clearly what you're looking for in a UK financial regulatory system is something a little bit more than just pure functionality. So what we've got at the moment is this slightly messy patchwork of lots of different pieces of legislation, lots of different sources of legislation, and then also, as you can see in the final four columns of the table on this slide, lots of different processes for amending that legislation. So it means you're in a situation where you've got a framework that's tremendously complex, and it's also quite inflexible. So if you look at, I suppose, the complexity, I mean, again, I think the slide illustrates it quite nicely, that you've got a number of different sources, some of them have been amended. It's actually quite difficult at the moment to find a single consolidated source for any particular piece of legislation to be absolutely certain that you've got the latest version. So we've got 32 EU regulations on financial services, we've got 189 statutory instruments, a whole patchwork of delegated and implementing acts, equivalence decisions, technical standards, exit instruments. So, there's just this massive range of pieces of legislation. And then looking at the inflexibility side of things, so obviously anything that you can see tagged as red here requires an act of parliament in order to be able to amend it. So clearly that's not a quick process. There's limited parliamentary time. It obviously means then that you've got a lot of detail in actual legislation, but no real ability for the regulators to be able to make targeted amendments. So you do have to go back to Parliament in order to make those changes. I think the other concern is that as time goes on, this isn't a situation that's just going to naturally resolve itself. It is going to be, without actual changes to reform it, this is going to be a situation that just gets worse and worse over time, because you have more and more changes to all of these different pieces of legislation. I think also a key issue is the limits on legislative capacity. So the actual time limits, time constraints and capacity constraints on the ability of Parliament and Treasury to make these changes. So if you look at the EU legislative pipeline, there's a lot going through that in any one year. I think in contrast, if you look at the UK, we've had 6 financial services acts in the last 20 years. So, you're not really comparing apples with apples here. You've got a much more limited legislative framework here, or legislative capacity. So if we move on to the next slide. So here we'd really aimed to show, compared to the previous slide, what the idea would be for the future model of regulation. So you're going from that patchwork of lots of different pieces of legislation back to something that's much closer to that FSMA plus statutory instruments model, which was the UK legacy process. So you'd have a single act of Parliament, or a few acts of Parliament. Clearly, you'd need an act of Parliament in order to be able to amend them, but that's just the overarching framework. And then under those acts of Parliament, they would give the power for either Treasury or for the regulators to take particular actions. So Treasury to make statutory instruments, and then the regulators to make rules or to provide guidance. And there you can see, so there's really only a limited number of sources of regulation. And then the appropriate person has the power to amend each piece of legislation or regulation. So acts of Parliament amended by Parliament, statutory instruments made by Treasury, amended by Treasury, regulatory rule books made by the regulators, amended by the regulators. So it's just a more intuitive system. But then obviously where that does leave you is a situation where, just by virtue of changing that regime, even without any particular policy decisions, we are going to end up in a situation where gradually we evolve as a UK financial services framework, we evolve away from the position that we've got in the EU. And that's going to happen in a number of different ways, partly different policy decisions in the UK and the EU, partly just as a result of the UK making these changes in order to be able to consolidate and update the UK regulatory framework. And then also, I suppose, less as a result of an active decision by the UK, but just because clearly the legislative framework rolls on in the EU. So the EU is making its own decisions, the UK is making its own decisions, they're not always going to be aligned. So you've got this, I suppose, process of active evolution or active divergence, where the UK takes a particular act and moves in a particular direction, and then also passive divergence, where just if we sat still and did absolutely nothing, we'd still be moving away from the EU because they're moving in the other direction. So maybe then just quickly to look at the building blocks, and we'll talk about this in a bit more detail. I'll turn over to Chris to talk about each of these items. But what we've got really for the 2023 reform programme is 4 overlapping elements. So we've got the Financial Services and Markets Bill, which was introduced to Parliament in July of 2022, and now currently in the committee stage in the Lords. So I think we're expecting royal assent before Easter of this year. And then overlapping with that, you've got the Edinburgh Reform Package, which was announced in December of last year. So this is really setting out more detail on the use of the powers under the Financial Services and Markets Bill, plus some additional provisions that aren't purely tied to the Financial Services and Markets Bill. Overlapping with that again, we've got the retained EU law revocation reform bill. So this was introduced to Parliament in September of 2022, also currently in the Lords Committee. Again, Chris is going to talk about this in more detail, but this one has been quite controversial, partly because of this statement that any EU law left on the statute books by a particular date will be sunsetted, so automatically repealed. And then on top of that, you've got a whole framework of other initiatives. So you've got business as usual initiatives from the regulators, from Treasury, and we've got some changes connected with the Financial Services and Markets Bill as well, and then other changes which are completely independent from the process. So things like, for example, the new UK consumer duty. So I think that gives a kind of framework for all the building blocks, I suppose, in terms of other sources to look at for what it is that the regulators are looking at doing. Over the last couple of years, the PRA and the FCA have published this regulatory initiatives grid, which gives a timeline, so it gives a fairly comprehensive list of legislative reforms, regulatory reforms that the regulators are thinking of making, just gives a little bit of a description and then gives you a bit of a timeline, and also tracks where that timeline's shifted as well. And so that's been a tremendously useful resource over the last few years, and I think is going to become increasingly useful over the next period as we see a huge amount of change as a result of these building blocks that are set out on the slide. So Chris, maybe over to you at this point.
Thanks. So just dealing with the first of those building blocks, the Financial Services and Markets Bill, we have the bill, sort of fundamental core part of the bill is putting in place the future regulatory framework that Caroline described. So the bill, if enacted, will revoke most retained EU law on financial services and markets from days to be appointed by the Treasury. That's all the 32 regulations, 189 statutory instruments, delegated implementing acts, equivalence decisions, technical standards, exit instruments, and a very limited amount of primary legislation, and a sweeper clause to catch other legislation EU-derived legislation relating to financial services and markets. So it's a pretty comprehensive package, but it doesn't revoke regulators' rules. That's left to the regulators to do. There isn't, in contrast to the retained EU law bill, there isn't a sunset date, so the Treasury can specify when this revocation takes effect. It's not bound by a particular deadline. And also, unlike the proposed in the retained EU law bill, there's no power to retain any of this, with limited exceptions under the sweeper clause. So the idea is all this stuff that's specified should go. It should disappear at some point. And then the Treasury is given very broad powers to save and restate that revoked legislation. So it could take the short selling regulation, for example, and restate part of it. It might do that using other powers, but it can save and restate the legislation, and it can amend any restated legislation on an ongoing basis. So it's given a very broad legislative power as a result. It also has given these new powers for the designated activities regime, under which it can designate particular activities, prohibit anyone from carrying on those activities without complying with the conditions in the regulation or absolutely, and regulate them and delegate powers to the FCA to regulate those activities. So the idea is to deliver the future regulatory framework by revoking the existing rules, using their powers to restate that legislation, or put it in the form of designated activities regulations, and so in the end deliver what the objectives were, which was a UK regulatory regime largely structured as PRA or FCA rules, and giving the regulators greater discretion as a result to amend those rules than they have today. The bill also has some other things sort of on the side, which are not, I mean, the fact they're on the side doesn't mean that they're not important. So pending revocation, the Treasury also has, the bill also makes some immediate changes to retained EU law, so particularly to implement the results of the of the UK Wholesale Markets Review. It also gives the Treasury transitional powers to amend or restate legislation before it is revoked, although the Treasury has sort of indicated that it intends to make relatively sparing use of that power, of those powers. It does quite a lot to the regulator's objectives and mechanisms for accountability we won't dwell on. And then it has a number of specific new regimes on critical service providers, financial market infrastructure, digital settlement assets, insurance solvency, and financial promotion. So, there's quite a lot of specific law, not just around the financial, the new regulatory framework. But notably, at the end of this, in the bill, we don't really get much idea of how these powers are going to be used. Very little idea of the planning was set out in when the bill was introduced or in the process. And we really had to wait for these Edinburgh reforms to get a much clearer idea of what the government had in mind. And so when Jeremy Hunt went to Edinburgh in December last year, he set out a sort of bundle of reforms. One part dealing with what is politically rebranded now as the smarter financial services framework, this sort of like move away from the future regulatory framework, the government's branding of this program, describing how the powers are going to be introduced. And then a set of more than 30 measures, some of which are linked to that, the use of the powers, and some which are completely independent of it. So we can't, as what we've done here on this slide is try and sort of regroup them into the sort of buckets of wholesale markets, retail and consumer business, and so on. And so that gives you a bit of a better idea of how the various pieces of the reforms fall. What is also interesting about many of these reforms, sort of the specific reforms, is none of them were really particularly new. Most of them took were building on a previous consultation or announcement or task force or whatever. And so, I don't think we really saw anything startlingly new coming out of this, but what the announcement did is pull that all together in one place. Some of these specific reforms use the powers under the bill, but some don't. So SMCR review, for example, doesn't need necessarily any new powers under the bill. It could be done by other means. And a lot of this has nothing to do with retained EU law at all. So SMCR, ring fencing were not really part of EU, retained EU law. Those were UK specific actions. And so, the UK is now acting to change things that it put in place before we left the EU. So what do we learn from the Edinburgh reforms about the way in which the smarter, what we call the smarter financial services framework will work? What the government has done is group the retained EU law that's going to be revoked, all that legislation which I sort of casually described, Caroline casually described, into 43 bundles, core files as it calls them. Sadly, 43, not 42 for Hitchhiker's Guide to the Galaxy fans. The answer should have been 42, but it wasn't. And so we have 43 core files. And then the government identified some of these as what they call tranche 1 and tranche 2 priority files for work during 2023. Tranche 1 was the Wholesale Markets Review, which many of you will be familiar with, the Listing Review, Lord Hill's Listing Review, Securitization Review, and the Solvency II Review, all of which had sort of been significant advances on that already in the period leading up to the announcement. So I think people knew fairly well where we were going on that. And then 9 further files in light green on the slide, which cover other things which the government plans to do as part of these tranche 1 and 2, the tranche 1 and 2 program. And alongside that, it also published 3 illustrative statutory instruments indicating how it might use the power, not strictly for consultation, but it has invited, people are putting in comments on them. One of them's on securitization, one on prospectuses, and one on payments. And what's interesting about the SIs is they use 3 different groups of powers. One of them, the securitization SI, uses in part the restatement power. The securitization and prospectuses SI use the designated activities powers, and the payments SI uses the transitional powers, actually, slightly surprisingly. And I think what you can see from them is pretty much an incremental approach. The government has said it doesn't plan to do changes for change's sake. And so the changes there are incremental, I think, rather than radical. They, in many cases, preserve the sort of framework and wording of previous EU legislation. So we're not dumping everything in this process. We're carrying on using much of the same wording and structure of the previous EU legislation, with some surprising departures. I think Caroline may mention some of the ones on prospectuses when we come to that in the more detailed part of it. But of course, what we don't get from the SIs, because of the framework, is we don't know what the full detail will be, because of course much of it will depend on the rules adopted by the regulators, and they haven't yet indicated what they will do with those powers. I think the other thing that you would draw from those SIs is that the landscape will be quite complicated. So you will have, we do get rid of 32 EU regulations, but we may end up with 32 standalone SIs replacing those regulations. I don't think that will be the structure, but you could end up with that sort of framework, because each one of these regimes requires some sort of it doesn't all necessarily quite fit neatly into sort of boxes under the current framework. So we may end up with quite a lot of statutory instruments on top of a highly expanded rule book at the regulators level. I think the other thing that is true when we look at these reforms is we don't really know what substantial progress is. The government said they plan to make substantial progress by the end of 23 on the tranche 1 and tranche 2 files, but we don't know quite what that means. Does that mean it'll be enforced or adopted, or what? We don't have a clear timetable. We don't have a clear timetable when the regulators are going to consult on a lot of these measures, and no clear deadline for a lot of these measures, nor do we know, bearing in mind we're only talking about 11 files out of 43. What is the timing on the remaining part of the program? The only thing we know there is that the government has said that the whole program will take a number of years. So I think it's slightly dispiriting, but I think when you look at it from the point of view of AFME members, we have to realize, of course, just moving on there, sort of graying out the bits that are probably of less concern to AFME members, that narrows down the areas of change quite a bit. We don't, AFME members are not primarily focused on payments or insurance and consumer credit and so on. So, we do get rid of some of it. And also, when we look at what the government has said on timing, we do have in the near term a guide to what the government is looking at, because, at least for the first quarter, we can see what the government has committed to in terms of actual consultations that are out there and planned consultations and announcements for this period. So we can see in this period, a number of consultations on Basel, on PRIPS, and on the short selling review, which are current. And so, this is something with which members, need to engage now if they have interest in these. And we have coming up in the first quarter, some important things, particularly the SM and CR consultation on the review there. And for those affected, I think the potential changes on ring fencing and resolution, are pretty significant. And green finance strategy, we don't really know yet the direction of that. And I think Caroline's going to talk a bit more about sustainable finance when we have turned a bit more to the deep dive area. So you can see in the short term, there's quite a lot of sort of detail about what's expected now. I mean, there's one, we have to remember that they did actually make one or two substantial, changes immediately. The reporting change, for example, on loss reporting, actually, there was one concrete change there. But when you go further out from that, you can see it thins out quite a bit in terms of, what to expect. Second quarter, we have relatively little detail, and we don't know when the SIs will be adopted, although, perhaps Q3, perhaps Q4, it may depend on when the regulators do their consultation. So if we just then turn to the next building block, which is the retained EU law bill, and it's important to note, I mean, Caroline said this is controversial, and it is controversial, and it may indeed, it is conceivable that it wouldn't even indeed become law. What we expect is, the Lords will probably make some fairly significant amendments. It'll get kicked back to the House of Commons, and then we'll see in the process of ping pong whether the government is prepared to use its majority in a way to get its way with this. But what this bill does is deal with the sunsetting of the retained EU law that isn't covered by the Financial Services and Markets Bill. So essentially, that whole idea that retained EU law comes to an end on 31st December 2023 if it hasn't been previously revoked, with some power to extend that deadline till 26. Just does that process, that mechanism just doesn't apply to the retained EU law that's covered by the Financial Services and Markets Bill. But that doesn't mean that this bill has no impact on financial services. In the first place, some of the legislation that falls within the sunset is important to financial services. So, for example, legislation on choice of law, the Rome regulation, or some of the accounting rules, and so on. So there are things in there that that financial firms care about. There's also some overlaps where it's not clear whether legislation falls within the retained EU law bill or the sweeper under the Financial Services and Markets Bill, things like remit on regulation on energy market integrity and transparency, some of the consumer law, which applies to both financial services and other businesses, and emissions trading, for example. It's not quite clear where that falls. So that boundary is important. Also, the second feature of the bill, which is mentioned on the slide, is this removing of the special status of any retained EU law remaining in force after the end of 23. This is, I mean, this could be a largely symbolic change. Retained EU law will become called assimilated law after that date. The residual supremacy of EU law will disappear. The courts will no longer be required to oblige general principles of EU law in interpreting it, and so on. So this sounds sort of largely symbolic, but it does mean that there is a possibility that if there is retained EU law on financial services in force at the end of 23, which there clearly will be, the risk is the interpretation of it or application of it may change as a result of this change to special status. I think it's fairly unlikely, but it can't be ruled out, and that is something which is of concern. The third element is that the government would have parallel powers under the bill, the revocation bill, the real bill, to amend, restate and revoke and replace retained EU law, including law covered by the FSM bill, but it's highly unlikely that it would use those powers. It would rely on its FSM bill powers, one, because those are going to be in place earlier, and secondly, on the whole, they're much broader. So I don't think that that is likely to be used. So that's the third building block. And the final one, which Caroline mentioned, I'll just hand back to her in a second, is the other initiatives. And this slide is sort of a reminder, there's quite a lot of other things going on, some of which are linked to what we've just talked about, but others are independent of it. So we have, in the first bucket, as Caroline mentioned, the consumer duty, but we've also got, the FCA looking at big tech. We have the whole crypto promotion, crypto regulation, future framework, which the government launched recently, and covers some things under the bill, but going further and looking at a range of different ways of regulating crypto assets. We've got sustainable finance. We've got, under the prudential governance regime, we've got the bonus cap going, which was not mentioned in the Edinburgh Review, I think, because it got so much flack when it was raised in the mini budget. I think it was pushed back to the regulators to deal with, and they pushed it out rather late in December, I think, perhaps when nobody was really looking, but it is there as going. And down on the other, we've still got LIBOR trickling along there as an important topic. We have AI regulation, where the UK approach is yet to be fully developed, and we have some detailed things on EMIR, where people are worried about the expiry of the temporary intergroup exemption regime, TIGER, that was introduced as part of the exit arrangements, and the expiry of the equity options derogations, which have to be sorted out this year. So as you can see, the other initiatives are quite significant, and mean that we've got a lot of other things are going on there as well. These are mostly identifiable and in the shorter term. With that, I'll hand back to Caroline.
Brilliant. Thanks very much, Chris. So yes, I think we're probably just going to spend the last 10 minutes or so just going through some of the broad buckets of specific changes that are being proposed, and then we'll turn it over to members for questions. So just looking at the selected topics that we've got on the slide, so just to look at wholesale markets, sustainable finance, capital markets, and then other. I mean, maybe starting with wholesale markets here. So because I think probably the bulk of the major reforms that are going to be of interest to AFME members are probably in either the wholesale markets bucket or the capital markets bucket. In wholesale markets, I think probably the main things that we're looking at here would be, first of all, the proposed reform of the overseas framework. And then we've got the wholesale markets review, and then just a super quick look at the short selling regulation. Maybe if we start with the proposed review of the overseas framework, I mean, I think this always sparks a bit of panic whenever it comes up, because people hear overseas framework and they hear repeal of the overseas person exclusion. And obviously the overseas person exclusion is only part of the UK's overseas framework. I think when HMT and the regulators talk about a review of the overseas framework, they don't just mean specifically the overseas person exclusion, they also mean all of the provisions that regulate cross-border business, not just for firms, but also for trading venues, for CCPs, so just across the whole gamut of regulation. And while clearly there probably is space for some sort of reform of the overseas person exclusion, or certainly simplification, but I suspect that probably from the industry's perspective falls into the bucket of, everyone knows how it works, or everyone has an idea on how it works, so please don't make changes, because it doesn't seem to be an upside to that. I think outside of that specific context, our overseas framework is in a lot of different places. I mean, particularly if you look at the framework for incoming financial market infrastructure, for trading venues, for CCPs, they're subject to a whole range of different exclusions, different designations that they have to get different equivalence regimes, and there is certainly potential there for some kind of consolidation or potential simplification of the regime. So that I think is something that's going to be quite interesting to keep an eye on, and certainly has been flagged by the regulators as a priority for 2023. And then looking at the wholesale markets review, so on this one, I think we don't have a single unitary idea of what the timing is going to be for this. The FCA has indicated that it's taking a staggered approach to implementation. And I think, a lot of this makes a huge amount of sense, because really what they're starting with is consultations on the proposals under the wholesale markets review, which they actually have the power to implement themselves. So it makes sense to start with things where you've got the existing power right now, consult on the change, make the change, and then anything that you don't have the power to do gets pushed to a later date. So they're starting with consultations on anything that they have the power to do, anything that's either in the rule book or that isn't yet addressed. And then the idea is further down the line, they consult on other reforms which are linked to proposed changes in legislation. So things like the Financial Services and Markets Bill, giving them additional powers to make particular rules. Looking at what the wholesale markets review is likely to bring about. So development of a consolidated tape. Again, that's not something that I think fills people with a huge amount of enthusiasm, certainly in the European context, but hopefully would be more straightforward and potentially more useful in a UK context. I think the government currently considers this as a priority for fixed income, but while that might be the government's priority, the FCA is still expected to look at the impacts for fixed income, for equities, for pre and post trade transparency, pre and post trade data. So they're conducting a broader review of the utility and ability to operationalize a consolidated tape in the UK. So I think there we're expecting to see further consultation on this one. An area where I think we have seen a bit more detail is the proposed changes to pre and post trade transparency, at least in the equity space. So I think non-equities has been parked for the time being. So in July of last year, the FCA published a consultation paper on improving equity secondary markets. So that consultation closed in September of last year. The FCA is currently reviewing the feedback that it received. And then obviously once it's chewed through the feedback, it'll produce a feedback statement and then potentially final rules. So here really they're looking at improving the content and consistency of post-trade transparency reports. There's a new proposed designated reporter status for OTC trades, so potentially replacing the systematic internalizer regime. We've got a proposal to allow UK trading venues to use reference prices from non-UK venues, where those venues meet certain criteria. So where the reference prices and the data published by the venues is robust, reliable and transparent. And then also potential for permitted use of tick size regimes from overseas primary markets. And then aside from that, we've got a proposal to realign the scope of the derivatives trading obligation, which had obviously fallen out of line with the derivatives clearing obligation. A deletion of the share trading obligation, changes to the definition of systematic internalizer. I think that's going to be quite an interesting one to watch, because while the systematic internalizer regime originally started out as being essentially how you tell whether you're within the scope of free trade transparency or not, it has ended up being referenced in a number of other different places. So if you have the current free trade transparency regime for systematic internalizers replaced with some sort of designated reporter regime, I guess the question is there still a need for any kind of concept of systematic internalizer? And if there is it possible to have a definition that actually works across all the different places in which it's used? So, I mean, particularly one area where it really doesn't work is in the benchmarks regulation. So I think that is going to be quite an interesting one to watch. And then we've also got some proposed changes to the commodity derivatives position regime. And again, this is one of those areas that the FCA already has the power to make changes in. And then finally on wholesale markets, looking at short selling. So the government's consulted on a review of the short selling regulation, and they've broken it into two parts. So the scope of the short selling regulation obviously being broadly short selling of equities, and then short selling of sovereign debt and debt related instruments. So they've broken this review into two parts. You've got a current review of the equity short selling regime. And then at the end of that, they said, well, we'll be consulting on the sovereign debt side of things a little bit later on. The review of the short selling regime, I mean, really at this stage, it's just a call for evidence. So essentially, they're asking the market what changes they might want to see to the regime. And then as part of that, there was a request fairly recently that if people have strong views on the sovereign debt side of things, they should make that known as part of the response to this consultation. Because if there aren't any particular strong views, then the government probably won't carry on and consult on it. It'll just keep the regime as is. So I think the likelihood is that what we're going to see out of this is probably pretty minimal changes to the regime. And I think this is maybe a bit of a theme that we're going to see with some of this regulation, that where people have already gone through a process of implementing the requirements, and people have gone through a process of interpreting some of the areas where it's less than clear, coming to a position, implementing those across their global organization, there isn't a huge amount of appetite for reform of that. And so suspect that on the short selling front, we're not really going to see a huge amount of change. Maybe then if we go down a box to capital markets. So, and I think here probably the main changes, or the main discussion around what changes might be made, are first of all the Austin review, which followed on from Lord Hill's listing review, which was published in 2021. And then the draft prospectus SI that Chris already mentioned was published alongside the Financial Services and Markets Bill. Maybe if we just look at the Austin review, first of all, because as I mentioned, this was building on Lord Hill's listing review. And the idea really here was to pick up on some of the recommendations that Lord Hill made and to make them more specific, with the aim of strengthening the UK's position as a world-leading financial centre, listing venue and incubator of growth companies. So the key recommendations that were picked up on in the review, first of all, enhancing the preemption regime. And here the idea was to put in place a more formal governance structure and then requiring a dedicated website with a searchable database of preemption regime information. I think this is really more for the official sector than for institutions, but again, potentially a helpful development. And then there were a number of proposals around capital raising. So a proposal to increase the ability of companies to raise smaller amounts of funds quickly and cheaply. And essentially here looking at the temporary regime that was put in place during the pandemic, allowing companies to issue up to 20% of their issued share capital. So the idea here was that this regime should be made permanent and subject to similar regimes to that temporary COVID-related regime, similar conditions to that temporary COVID-related regime. And then also with a requirement for public reporting on how the issuance was carried out. And when they say how it was carried out, they're thinking compliance with the conditions. So confirming that key shareholders were consulted, confirming how people dealt with the interests of other investors and retail investors. And then talking about retail investors, so there's also a proposal to involve retail investors in all capital raisings, and to introduce additional requirements around IPOs that involve a retail offer, so ensuring that the prospectus is available to the public closer to the end of the offer period, so at least 3 working days before the end of the offer period. And then we've got a proposal to reduce regulatory involvement in larger fundraising, so again aiming to make the process of secondary capital raisings just more streamlined and less bureaucratic. So the idea here is that where someone's already launched an IPO, they've already published a prospectus, investors have already made decisions around whether or not they're going to invest in it, and they already have a significant amount of public information out there, there should be, as a default, there wouldn't be any further regulatory scrutiny of further issuances. And then obviously, there'd be circumstances, and so that's the default position. So there'd be circumstances in which that's reconsidered. But the idea really just to make things more streamlined for capital raising purposes. And then again, requirements around or proposals to make existing capital raising structures quicker and cheaper, so shortening the offering period for rights issues and open offers, and then increasing the choice of fundraising structures for companies. Here, I think they don't, the Austin Review didn't really propose any particularly concrete ideas here. So they mentioned again more involvement of retail investors. They mentioned again reducing the time and cost of larger fundraisings. Other than that, I think they said Australia's got a good regime for accelerated fundraising structures, so that might be something that we could look to implement in some form in the UK. And then because the digital economy is obviously at the core of the UK's plans for its future, the final point in the Austin Review is around the drive to digitisation. So those are all proposals, and we don't have any specific timelines associated with that. I guess what we have seen coming out of that is the illustrative draft prospectus statutory instrument, which would replace the prospectus regulation. And partly this is aimed at addressing some of the points raised in the Austin Review. Partly it's also aimed at bringing mini bonds and other transferable securities where there isn't currently a prospectus requirement within the scope of the prospectus regime. So this was published as an illustrative SI alongside the Financial Services and Markets Bill, alongside the Securitisation SI. They were two illustrative SIs. They weren't originally published for consultation. What the Treasury originally said was that these are being published so that you can see the kind of changes that we're thinking of making, the format that we'd make them in. They're just for illustration. And also, I think there was a very clear statement that there'd be further changes to come. And as time's gone on, the view seems to have shifted. So really Treasury and the government very much looking for input on these SIs, because it does look as if actually this might be very close to the final form. And so, you know, what we've seen recently, I think, from AFME, from ICMA, from a number of trade associations, is a increased focus on the specific requirements of the SI, because actually when you start to unpick it, it's not just about implementing the Austin reforms. It's not just about, making the prospectus regime work for the UK. Because of this mini bond requirement, they've massively expanded the scope of the prospectus regime in the unexpected directions. So we've now got a definition of, so transferable securities are in scope, also something called relevant securities, which essentially seems currently to cover pretty much anything that you can buy or sell. So would cover lending, potentially would cover deposit taking, would cover, a whole derivatives and a whole range of things which no one currently thinks of as securities. So some potential pitfalls there. And then just we want to leave some time for questions. I think maybe if we look quickly at sustainable finance. So here, this was, again, alongside the digital economy, it was one of the areas that the UK flagged as being a key area for focus for UK financial services regulation. And that process is maybe, I'm not sure whether it's been hampered or helped by the sheer volume of data that's been published by the EU. And certainly what the UK is looking at doing maps to the EU agenda to a certain degree, but on a much, much smaller scale. So we've got a regime for non-financial disclosures around sustainability. We've got requirements under the Companies Act for companies within that regime, and then all the standard listed companies as well. And then we've also got a consultation from the FCA on product labels and the UK's version of the asset manager disclosure regime that we've seen in the EU. So here we've had consultation on that at the end of last year. The consultation closed actually just a couple of weeks ago. So I think we're expecting to see further rules from the FCA by the end of the first half of this year. The other point that the flagged that it was going to develop was a UK taxonomy. And here, I think for anyone who's followed the development of the EU taxonomy regulation and the amount of detail, the amount of technical work that's gone into developing the taxonomy, I'm not sure that the idea of having a separate UK taxonomy is filling. Obviously, we're not going to have the same political concerns around, for example, nuclear power and gas, which we've had in the EU, because you've got a single political agenda. But yeah, I mean, just the potential for the UK to have a similar but very slightly different taxonomy for what constitutes a sustainable investment, and then eventually a socially responsible investment, I think just potentially raises the concern of people having to implement different disclosure, monitoring, reporting regimes, and also potentially raising barriers to cross-border business as well, because you need to try and make sure that you're compliant with both sets of regimes. And then just to finish up, looking at that bucket of other, say, I mean, Chris already regime and the potential for that to be reopened. Again, here, I think you've got a similar issue with the short selling regime, that people have already implemented it, and there's maybe limited appetite to make wide-ranging changes. Certainly, a lot of the process around it could be made less bureaucratic, could be streamlined, there could be a much faster and approving people as senior managers. But beyond that, I think there isn't a huge amount of appetite that we've heard about, certainly, for change. And just very quickly, I mean, it's a massive topic to end with and to cover in 30 seconds, but the UK's Basel III implementation and the proposed version of the capital requirements regulation. And I think partly this is interesting, because what we're seeing here is a partial revocation of a European regulation. So for things like the prospectus SI, for things like short selling, what we'd be looking at is complete revocation and replacement with relevant regulatory rules. I think with CRR, what we're seeing is an acknowledgement that there's too much for anyone to bite off in one chunk. So what they're going to do is break it down into pieces. There's going to be particular areas of CRR that are repealed and replaced with PRA rules. And that's going to be a bit of an iterative process. So what you're saying is also an iterative process with the consultation papers, because you can see the government consulting on repealing bits of CRR, but also saying exactly what we repeal is going to be what they want to do with their rules. So that sort of initial stage even isn't completely finalized. And then once that's been implemented, we're going to go through a stage where we've got a patchwork of pieces of the capital regime, some of it in CRR and retained CRR, some of it in new PRA rules. And because of the way that the competencies are split between the PRA and between the Treasury, things like, for example, anything that involves an equivalence decision for a third country regime remains the competence of the Treasury. So you've got requirements which are now going to be in PRA rules, but where the, for example, risk weighting of particular non-UK instruments depends on an equivalence decision that's made by Treasury under CRR. So just going through that process of trying to track how you work out what the risk weighting of those third country instruments is, and given that in that particular example, you know, you need to work out whether you can just look at the PRA rule book or whether you need to be fishing around somewhere else. And actually, if you need to know not just what the PRA rules are and where to find the policy statement, the statement of policy, the feedback statements, everything that's relevant to interpreting PRA rules, you need to know all of that. You probably also need to know where that rule was originally founded in CRR, so that you can go back to CRR and see if there's anything left in that article that's relevant now to your interpretation of those rules. So I think that's going to be a really interesting one to watch, because it is a bit of a test case for how we're going to go from that original frozen landscape that we set out at the beginning to, you know, the bright new future of the UK regulatory framework that we're heading towards. So I think with that, probably back to Julian.
Thank you very much, Caroline, and thank you very much, Chris. That was an absolutely fascinating, slightly overwhelming tour of the waterfront of all the changes that are going on in the UK. We've had over 200 members join us, so thank you very much. It's obviously a very pertinent topic, very, very high on members' thoughts at the moment. We only have a few minutes, so perhaps for a couple of very quick questions. I'll chunk them into themes. Effectively, members were questioning how they could put together their to-do lists in 2023 and thinking of their priorities in terms of resources and timings. And I think, Caroline, you spoke very clearly around references in the bill to implementation on a day or days to be appointed by the regulators. And we've heard from the Treasury substantial progress should be made in 2023 on tranche 1 and tranche 2 in their recent December policy statement, and that the whole program of change is likely to take a number of years. It will be a multi-year project. Are there any timelines that members can work to, or what are your thoughts on their priorities? Very big question for a very short answer.
Yeah, I mean, I think you've probably given as much clarity as we've really got on the timeframes. So, you know, on the tranche 1, tranche 2, obviously all we've got is a statement that they want to make substantial progress in 2023, which is great. That means that we've got a list of things that are going to happen to some extent in 2023, but no indication of what's going to be done. You know, what actually does substantial progress mean? Does that mean the rules are actually going to be made in the course of 2023? And even if the rules are made in 2023, when's the implementation deadline going to be? And so I think really it's only those areas where we've actually had specific consultations from the FCA where we do have some degree of certainty around the timeline, because for those consultations, the FCA knows it's already got the power to make the changes. They've consulted, and then after that, they have an established framework. So we know they're going to publish a feedback statement within X period of time. And then after that, the rules should be effective again within X period of time. But unfortunately, it means that we don't have tranche 1, everything's going to be in effect by X date, tranche 2, everything in effect by Y date, tranche 3 after that. It is very much going to be a case of looking at each of the changes that's being made and working out how that, you know, at what point in time that's going to be effective.
Thank you, Caroline. And we can, all we can do is continue to press the government through fora that we jointly sit on as well, such as the Treasury's Future Regulatory Framework implementation group. So we will continue to press for clarity. And perhaps in the last minute, Chris, I can ask you around, you know, given the huge range of regulatory initiatives and the great significant changes that we've identified in the presentation, have you got an indication of those areas that the AFME members might consider the greatest impact on their business, you know, perhaps operationally, in a legal or contractual sense, or in terms of compliance, overheads and reforms?
I think inevitably the wholesale market review is going to present a number of specific challenges for firms. I mean, hopefully a lot of this is just getting rid of things, you know, so abolishing the share trading obligation shouldn't be too much of a problem for firms who just switch something off. But, you know, other changes like implementing a designated reporting regime, you know, could require actual compliance work by firms. So I would single that out. But I think the other general point on changes, and I think we can see this with the prospectus and securitization draft SIs, actually working out whether there is a change at all that's happening. And I think this is something the industry has called for very strongly from the government, and I don't think we've actually really seen it, which is that where rules are being revoked and being replaced, you know, the industry has said, you know, it's really critical to know whether the government or the regulators making change actually want a change in practice as a result of this. And actually, when you look at, you know, what they've done in relation to the policy statement, I don't think they really tell you that. You know, they didn't really single out the changes to the scope of the prospectus regime or explain what that meant in the policy statement. You know, they just put it there, and it was firms had to work out, oh my goodness, this affects lending, this affects derivatives, it affects all sorts of other things. You know, so I think that issue of identifying change is really difficult and really important, and we really, I think, have a reason to expect something a bit better from the public, from the official sector, about what they are actually proposing and what it actually means for firms. They must have some idea of the change they're intended to achieve, and they should say so, it seems to me, much more clearly than they have done to date.
Thank you very much, Chris and Caroline. I'm afraid we're over time now, so we could talk about whether the FCA is appropriately resourced, or indeed is it culturally orientated to take on such a massive task once it receives the onshore EU law into its rulebook. And we could also haven't had an opportunity to talk about divergence, and you know how we could categorize some of that divergence. And yes, Caroline made some interesting remarks around, you know, diverging actively or passively as well. Chris and Caroline made remarks on that. So it only remains for me to say thank you very much to you for your very insightful comments. Thank you to members for making the time to listen to this. Do feel free to contact me for any of the topics. We're working on over 90 UK centric work streams here at AFME, and if I can be of any assistance to you, and I certainly will do. And there are a lot of open consultations to engage with, task force to feed into, an industry fora to influence. So I think we will all collectively be kept very busy during this time of great change and uncertainty. So thank you very much, everybody, and I'll close the call now.